Do you have a loved one in jail suffering from a mental health condition or serious substance abuse? Has serious substance abuse or mental illness affected your life and led you to become charged with a criminal offense? If so, we may have a unique opportunity and a unique solution for you to get the treatment that you need while getting your case dismissed. Please stay tuned to the end of this video where we're going to discuss one of the most exciting programs in California today, Section 1001.36, Mental Health Diversion. Hello, welcome. My name is William Pernik. I'm a criminal defense attorney. I'm joined this morning by Sarah Schumacher, who's one of the senior staff attorneys at my firm. And this morning we're going to discuss with you a really exciting program that has been recently introduced and revised in California called Mental Health Diversion. Good morning, Sarah.
Good morning.
It seems to me that in the last 10, 15 years, I'm seeing more and more cases involving mental health and substance abuse. It just seems like the number of clients whose lives are impacted by mental illness or drug addiction or alcoholism have never been higher. Do you have similar experience in your practice?
Absolutely. The vast majority of cases actually that I've come across in criminal court involve someone that's either suffering from a mental health disorder, whether diagnosed or undiagnosed, or a serious addiction issue.
Now, up until maybe 6 or 7, 8 years ago, it was extraordinarily difficult for us to obtain positive results for clients who suffered from mental illness. And that was for a number of reasons. Number one, a lot of judges and prosecutors were scared of people who they perceived as being crazy. People who suffered from mental illness were perceived to be dangerous. A lot of times, those people were deemed unfit for probation or treatment, and the only solution was prison. So it was very difficult to overcome many of those stereotypes, and we had to work very, very hard in order to come up with creative solutions in order to get folks the treatment they needed and avoid the worst consequences of their actions.
I agree. Jails and prisons, unfortunately, had become housing for many mentally ill individuals, and that's just not appropriate. Thankfully, mental health diversion was passed in 2018, and now there are treatment options available that would result in a client getting their case dismissed.
What I really love about this program is that it does not require a person to plead guilty to a crime or say the word no contest. What this program really is about is substituting ongoing criminal prosecution of a person, that means a criminal case that you have, for a treatment-based alternative. Treatment that usually requires some sort of outpatient counseling, perhaps visits to a medical doctor or psychiatrist, outpatient treatment for drug or alcohol addiction if appropriate, and it could really get very serious charges thrown out of court entirely.
The majority of criminal charges would qualify potentially for mental health diversion if a client has a qualifying mental health disorder, and as a result of that mental health disorder, this offense was committed. With the exception of charges that would require someone to register as a sex offender, unless with the exception of indecent exposure and murder or voluntary manslaughter, all criminal charges would fall under the umbrella of mental health diversion.
What that means is that if you're charged, let's say, with residential burglary, if you're charged with robbery, if you're charged with kidnapping, if you're charged with theft, if you're charged with fraud, if you are charged with hundreds and hundreds and hundreds of offenses out there, you could qualify for this unique opportunity to not suffer a conviction if you are eligible for this program, if you have a diagnosis or can get a diagnosis for mental illness and are willing to participate in a program of treatment. There is a couple of exceptions that are written into the law. For example, you cannot get mental health diversion if you suffer from antisocial personality disorder. But that's really obvious because if a antisocial personality disorder was eligible, almost anybody who commits a crime would be eligible, so the exception would swallow the rule. The other exception in the statute is that you cannot suffer from a pedophilic disorder. That's because the statute does not want to include, or the legislature did not want to include, sex offenders as a group eligible to receive this benefit. But virtually everything else, with exception of these really serious charges that Sarah just named, is eligible. Yes, you cannot get it if you have a charge of murder. Yes, you cannot get it if you have a charge of voluntary manslaughter. You could not get it for a sex offense, with exception of violating Section 314, which is indecent exposure. And unfortunately, recently there's been a change in the law that says you cannot get it for DUI. But just about everything else provides you with an incredible opportunity to save your life, get the treatment that you need, and not have a criminal conviction. Now, this is really, really broad. In fact, when we look at some appellate decisions that have recently considered the statute, our courts of appeals specifically are sending a message to trial courts that this diversion is intended to apply as broadly as possible. Once you have been diagnosed with a mental health disorder, either based on your prior medical treatment or based on the new evaluation that we will assist you in getting, then you will also need to show that this mental health condition played a significant role in the commission of the offense. Approximately a year ago, this law has been changed so that now your condition can be considered to play a significant role in the commission of the offense if it motivated criminal behavior, influenced criminal behavior, or caused it. That means we are now capturing a very large amount of cases where people suffer from mental health conditions and are now eligible to get the help they need that they previously could not attain. Pursuing mental health diversion presents tremendous benefits to our clients. If you're granted mental health diversion, you have a guarantee that your treatment will not be longer than 2 years on felony charges and will not be longer than 1 year on misdemeanor charges. This sometimes can be even shorter than a grant of probation you would receive on certain offenses. For example, for a crime of child abuse, probation is typically 4 years. For a crime of domestic violence, probation is typically 3 years. You can complete mental health diversion and have no criminal record a lot faster than you would otherwise complete a period of probation and then seek to have your record expunged. So, if you're not discussing this opportunity with your attorney, you should consider doing that today.
William, included in the DSM are substance use disorders. Can a client get mental health diversion if they only have a diagnosis for a substance use disorder?
That's a terrific question, Sarah. So, it is true that we have a lot of clients who suffer from severe forms of substance abuse, drug addiction, alcoholism. And oftentimes, these people too want to benefit from some form of diversion. Can they qualify under the same standard? And the answer, surprisingly, is yes. They can absolutely qualify because as our science has evolved, we now understand that addiction is product of mental illness. And so, methamphetamine use disorder, alcohol use disorder, cannabis use disorder, opioid use disorder, all of those conditions are actually listed in the same encyclopedia of mental health disorders that judges and psychologists are required to consult when they conduct eligibility evaluations for purposes of this new law. Now, Sarah and I practice in neighboring jurisdictions. Most of my cases are in the county of Monterey, and we also handle cases in Santa Cruz and Santa Clara. Sarah's primary courts are in Santa Cruz County and also in Santa Clara, so there are some differences in how different judges handle mental health diversions county by county. Sarah, could you tell us what happens in your home county?
So when a client's pursuing mental health diversion, we'll set a date for the judge to determine whether or not mental health diversion will be granted. I would file a motion saying that the client qualifies for mental health diversion. In my motion, I would include a summary of the facts as well as a qualified mental health professional's expert report stating that the client has a qualifying diagnosis. I would also attach a treatment plan which may involve appointments with a psychiatrist, may or may not involve medication compliance, may or may not involve attendance at AA or NA meetings or some other outpatient substance abuse treatment, and usually would involve some sort of individual or group counseling. I would attach that treatment plan to my motion, and the judge would determine whether or not to grant mental health diversion for this particular client. Once the judge grants mental health diversion, that period of diversion begins, the max of 1 year on a misdemeanor and a maximum of 2 years on a felony. The client would engage in treatment. We would get letters from that client's mental health providers stating that they're complying with their treatment plan. And as long as the client doesn't commit a new felony or a new misdemeanor charge involving violence, they would continue on their mental health diversion treatment plan. The client may appear for mental health diversion reviews, or their attorney can appear on their behalf as long as they're in compliance. And then at the end of that period of diversion, the case would be entirely dismissed.
Now, Sarah, you've mentioned some of the processes that are used in Santa Cruz County, which is the primary county where you practice. One of the differences that we see here in Monterey County is though we do have a trend to put cases in a central location, meaning there's one judge and one court that would be following up and handling mental health cases. On serious felonies, we're still seeing each department and each judge handle them individually. So we don't have a central location yet, like a centralized mental health court where all of these cases go. But my understanding is that in Santa Cruz County, at least based on several cases that I've done there, but you have done a lot more, in Santa Cruz County, the county has actually funded its own dedicated treatment court. Is that right?
That's correct. So there's the Collaborative Courts program in Santa Cruz County. So what that means is mental health diversion cases can be heard in what's called packed court for many cases, or may be heard in what's called BHC or behavioral health court. Once mental health diversion is granted in the home department, the reviews would generally, there are a few exceptions, but generally be heard in one of those two mental health courts.
So to summarize this video for you, if you or your loved one suffer from symptoms of either diagnosed or undiagnosed mental health condition, if you or your loved one suffer from symptoms of long-term drug or alcohol addiction, there is help available for you right now through Mental Health Diversion Program. This program is available in every single county in California, and it applies to almost every criminal charge, with exception for few fairly obvious charges like murder, voluntary manslaughter, or sexual offenses. It applies to almost any mental health condition. That means schizophrenia, bipolar disorder, depression, anxiety, even borderline disorder that has recently been included. It applies to conditions that have to do with your drug addiction. For example, methamphetamine use disorder, opiate use disorder, cannabis use disorder, and also methamphetamine-induced psychosis. There are hundreds and hundreds of mental health disorders listed in Diagnostic and Statistical Manual of Mental Disorders, and almost every single one of them could potentially make you eligible for this incredible opportunity. In order to qualify for this statute, you need to talk to your attorney about whether or not you have or should obtain a diagnosis for mental illness, whether or not you should participate in treatment. The answer should be yes. You don't have to go to a state hospital to do it. This is not the same thing as being found incompetent or being found criminally insane. This is treatment that you, your attorney, and your treatment team would design and propose to the court. If you qualify for this, you can get your charges of residential burglary. You can get your charges of robbery. You can get your charges of theft. You can get your charges of fraud. You can get hundreds and hundreds and hundreds of criminal charges completely dismissed. And all you have to do is get the help that you need, get the help that your family, that your loved ones want you to get help anyway, participate in the program, comply with the terms of it, and in less than 2 years on a felony case or only 1 year on a misdemeanor, your life will be free from these criminal accusations, your case will be dismissed, and your arrest record is sealed. So if you enjoyed this video, please click like, subscribe, send us your comments. We're really passionate about this topic. This is one of my favorite things to talk about. I know that you might have some questions. Please send us your comments, send us your questions, and we'll be happy to respond. Thank you for watching. I'm William Pernik, and this is Sarah Schumacher joining me in this discussion.
Thank you.